Welcome to the Procedural Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Today, a federal district court judge handed the Trump administration another blow in its efforts to defend and protect the southern border of the U.S. from illegal immigration. The president has repeatedly stated his intention to stop the migrant caravan from crossing the Mexican-U.S. border. Just recently, the president issued an executive order. The president's order, in short, said that he would allow asylum to be granted only to those who enter at a designated port of entry and deny it to those who enter at another location along the southern border of the U.S. A group of immigrants' rights organizations filed suit against the president the same day he issued the executive order. A federal district court judge just granted the request of the immigrants' rights groups and issued a temporary restraining order ordering the president to not enforce his new executive order. The relevant section of the Immigration and Naturalization Act, which is what the judge focused on, says this: any alien who is physically present in the U.S. or who arrives in the U.S., whether or not at a designated port of arrival, irrespective of such alien's status, may apply for asylum. However, in that same statute, the Congress authorized the Attorney General to, by regulation, establish additional limitations and conditions consistent with the act under which the alien shall be ineligible for asylum. So, the president was arguing that the second section that I just read gives the Attorney General the authority to impose limitations and conditions. The judge ruled it does, yes, but not in a way that abrogates or gets rid of the clear congressional mandate that individuals may apply for asylum whether or not they arrived in the U.S. at a designated port of entry. The judge wrote, Congress has clearly commanded in this act that any alien who arrives in the U.S. irrespective of that alien's status may apply for asylum. Before we get into the substantive law, well, I just gave you an overview of the arguments and the holding. I did want to discuss some procedural matters. The plaintiff in this group is a group of pro-immigration rights organizations. The Trump administration challenged their standing to bring suit, claiming they had no concrete or particularized injury. In fact, none of those groups were denied entry into the U.S. By this executive order. None of those groups or members of those groups were denied asylum as a result of this executive order. So, in my view, no concrete and particularized injury, yet the judge went the other way. The plaintiff group also had to prove irreparable harm if the court didn't grant this temporary restraining order, and I don't know how an immigration rights group is irreparably harmed by an executive order that's only temporary and only stays into effect for 90 days. It simply requires asylum seekers to request asylum at ports of entry where they can be properly inspected. That is beyond me, yet the judge found as such. Anyway, back to the substantive law. In 1996, Congress passed the Illegal Immigration Reform and Immigrant Responsibility Act, and as part of that statute, Congress provided that an alien present in the U.S. without being admitted or paroled who arrives in the U.S. at any time or place other than as designated by the Attorney General is inadmissible into the U.S. Aliens who enter illegally are therefore inadmissible in the U.S. under the congressional statute. And that's what the Attorney General was focusing in on. He was saying, look, these aliens, I can issue an order saying if you want to enter the U.S., you must do so through a port of entry. And that's what the Attorney General did. And if you don't, according to the statute, then if you enter in any other place outside of a port of entry, you're deemed inadmissible in the U.S., and that is what the congressional statute says. However, as we discussed In another section of that statute, Congress really clearly showed its intent that any alien who is physically present in the U.S. or who arrives in the U.S., whether or not at a designated port of arrival, irrespective of such alien status, admissible or not admissible, may apply for asylum. And that's really the section that the judge hung his hat on in this case. So the alien who arrives in the U.S. without using a port of entry may apply for asylum, even though his status in the U.S. is unlawful and he's deemed inadmissible. The court ruled that Congress's determination that place of entry not be disqualifying to an application for asylum. Does this make sense? Perhaps it doesn't. Under this judge's interpretation of the statute, an alien can be deemed inadmissible in the U.S., but even if the alien's inadmissible, he can still be admitted to apply for asylum. Now, we'll see how this case develops as it works its way through the civil justice system. This is simply the opening stage. It's a temporary restraining order that is in effect now. The president may not enforce this executive order at this time. By this coming Monday, November 26th, the parties must submit either a stipulation, which means an agreement, or competing proposals for a briefing schedule in advance of the December 19th hearing. So we'll have a hearing on this matter on December 19. If it's not continued, then we'll likely have more to say at that point. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I want to thank you for listening. I hope you learned a little bit about immigration law, and enjoy your lunch.